If somebody is arrested and they're brought to court, most criminal cases do not go to trial. Most cases are what we call plea bargain or pled out. It's in everybody's interest to try and get a criminal case finished as quickly as possible for both sides. For the prosecutor, they have many, many cases that they want to get rid of because they are so inundated with cases. And for someone who's arrested, it's a very tough situation to have that over your head on a daily basis. And it's always best to have the outcome of your case determined where you know what the outcome is going to be as opposed to going to trial. So what is a plea deal? A plea deal is basically both sides say, hey, here's the strength of our case, here's the weakness of our case, here's how we think it should resolve so it's fair to the person that is accused. For instance, what happens in a plea deal? On a simple case, perhaps on a DWI, driving while intoxicated, the proofs may be hard for the prosecutor to prove, so maybe a plea bargain will go down to a careless driving. In a criminal situation, somebody may be charged with stealing a lot of money, thousands of dollars. However, they either don't have a criminal record, they make a one-time mistake, and a prosecutor will say, you know what, I'm going to give you a break. I will let you go through some sort of a diversionary program so you don't have a criminal record. And in more serious crimes, the reason, especially that I will do it as a criminal defense lawyer, is my number one concern is to make sure that my clients do not go to jail under any circumstances. And if the facts work out in their criminal case, I will present that to a prosecutor and say, look, this is not an individual that deserves to go to jail for this sort of crime. The way that prosecutors or district attorneys will weigh whether they'll give you a more lenient plea deal or not, there's a couple of factors. The first factor, and probably the most important, is the person. A lot of people get arrested one time in their lives. They make a mistake, and we all make mistakes, and they make that one mistake that will put them in the criminal process. Most of the time, depending on the nature of the crime, a prosecutor will give that person generally a break. Part of the criminal process is to try and rehabilitate people. If you've never been convicted of a crime, odds are you're going to get a lenient plea deal. The second way is the nature of the crime. Usually nonviolent crimes are much more likely to be disposed with a good plea deal than a violent crime. So talking about things like theft, shoplifting, white-collar crimes, things like that. If the losses are not too great, most likely prosecutors will give somebody a plea deal based on the fact that they don't want to try the case and based on the fact that they may have a difficult time proving the case. In more serious cases and violent crime, lenient plea deals are usually not as likely, especially if the proofs against the person are great. Mainly the reasons somebody would get a lenient plea deal is A, they're a first-time offender, and B, it's the nature of the crime that's committed. But of course, every case is different. And this is just a general outline of why it happens, because that doesn't mean that somebody accused of a violent crime cannot get a good plea deal. If you've been arrested and you have any further questions about a plea deal, or would you be eligible for a plea deal, give me a call at the number below or go to my website, where I do have other videos about the best ways to negotiate a plea deal.